Welcome back. Well, the big story from North Block, companies like Vodafone, Cairn Energy and others facing retrospective tax demand in India will now have to withdraw legal cases and not contest the constitutional validity of the retrospective amendment to income tax laws. This if they wish to avail the dispute resolution scheme. This as per the second set of frequently asked questions that was released by the CBDT, or the Central Board of Direct Taxes, over the weekend. Timsy Jaipuria joins us now. Timsy, what else did the FAQs provide any clarity on?
FAQs very clearly said that all the retrospective tax cases prior to 2012, also when the amendment came into action, if they relate to the subject, can avail a benefit under the scheme, provided the cases have been filed by the taxpayer and not filed by the government. In every case where the government has filed the case, then government has no provisions to withdraw and help you avail the benefit of the scheme. So very clearly, no relief coming in the case where government has appealed against the taxpayer. The relief is only where taxpayer has appealed against the government, and only then they have to first withdraw the cases from the respective courts, and only then they can avail the benefit. Also, if they avail the benefit, they will have to pay once and for all. So no installment payments of the tax liability under the scheme. So another no relief, as we have seen in the earlier schemes such as IDS and all, where government gave a relaxation of paying in installments. Secondly, in the cases such as Cairn and Vodafone, where there are very tricky issues and there are typical cases which are the two biggest dispute cases that are pending, government has made it very clear that since they are in arbitration, only the taxpayer first has to withdraw the case, and only then they can apply for a relief. But let me tell you very clearly, till now what sources have been indicating, that Vodafone and Cairn have made it clear that they want to continue with the arbitration process. On the other hand, in the cases which are continuing, the disputes are clinging on even prior to 2012, and they are still going on. So specific cases where technical services fees are related, they are related to royalty payments, they all can also avail the benefit in the scheme. But all in all, if you see, government is very strict in a set of FAQs that they've released almost 5 days before the scheme expires. They've made it very clear that government does not want to give any more relaxation. If the tax is due, if you want to come in the scheme, you have to follow certain procedures where you have to first withdraw the case and then come in forward putting your application. And in case the government rejects your application, then the previous case which is going on in the respective court, whether ITAT, whether High Court, Supreme Court, or wherever in the legal channel, the case will continue. So all in all, no big relief, but yes, in case you want to take a relief, you need to withdraw your case.
Okay.
Back to you.
Okay.